Just one moment. We have 4 members present. We're gonna pause just a moment. Thank you for everyone who is here and attending the meeting today for the discussion. We'll probably get started in about 3 minutes. Folks who are online, if you could make sure that your microphones are muted, we're getting quite a bit of feedback. Thank you. So, Mr. McGregor, just let me know he's running a few minutes late, so he will be there.
Okay.
Go ahead and get started.
Sure.
Is that clock more correct? Or should we use mine?
It's not 04. It's just
So, good morning, everyone, and thank you for being with us today. It is 9:04 a.m. and we'll call the Zoning Advisory Ordinance Committee meeting to order. Mr. De Castillo, can you start with the roll call, please?
Sure. Good morning, Chair Hampton,
Present?
Vice Chair Blair. Here. Commissioner Popkin. Not here. Mr. Barron.
Present.
Mr. Hall.
So, Mr. Baring, in order for us to count you as present, we will need to have your camera on, please. Thank you.
I'll be at my computer here in just a minute.
You're good. You're not the first member to be en route. Thank you.
Okay.
We'll continue on with Mr. Reeves.
I'm here. Good morning.
Ms. Bagley. And Mr. McGregor. Okay, got 4.
Thank you. So we do have a quorum. So we'll, and I think I just see that Commissioner Popkin, are you with us this morning? I think I just saw you join. We'll circle back. I think she may be online virtually.
Madam Chair, really quick, a member of the public just texted me that they're trying to get online and it's asking for a password.
The password will be lowercase Dallas, all lowercase.
Lowercase Dallas. Okay, thank you.
Thank you, Mr. Reeves.
And Ms. Bagley is attempting to sign on as well.
And good morning, Ms. Bagley. So Commissioner Popkin and Ms. Bagley are also with us. Thank you all for joining us today. We'll be presenting our item today.
So good morning. I do not have an updated presentation as I wanted to let the conversation roll. I'll read the item into the record, right?
Yes.
Consideration, so it's item D 212002. Consideration of amending chapter 51 and 51A of the Dallas Development Code with consideration to be given to amending section 51.42161 lodging uses and section 51A 4205 lodging uses to define the new use called short-term rental lodging and related regulations. It's at the commission's discretion, I can do a refresher based on the last, on July 7th presentation, or we can just dive into discussion.
So I think I would recommend we go ahead and begin with questions unless there's anyone who would like to see the presentation. Seeing none, I'm going to move us on to questions. And as a reminder, I know we have a number of members of the public who are with us today. This is a briefing session and discussion for our ZOAC members. There will be no action taken at today's meeting. This is a time for us to ask questions of staff. So with that, I will open the floor for questions. I'm checking online.
I'll start.
Thank you, Commissioner Popkin.
I was reviewing the staff presentation to council in May and trying to remember where we were in the last conversation we had. I had a couple of questions related specifically to what I guess had been formulated at that point. Is that pretty much where we're at now? Should I continue with those questions?
Yes, generally. ZOAC had asked for some additional information, but the May council briefing session is what is reflected in our current case report, and staff's recommended, or the proposed amendments, excuse me, that are on page 2 of our case report. That's what's before us.
Okay. Okay, thank you for that clarification. And so I saw mentioned in there that a night inspection team would be, I guess, responsible for ensuring that short-term rentals are following the city's regulations in terms of parties and noise and those types of complaints. My question relates to where could the funding be coming from for that type of a new service that we would be offering? Would it be from permits, or have we identified that at all?
Good morning, Jeremy Reed, Code Compliance. So the registration program we are proposing will be under the auspices of Code Compliance. That registration would have a fee associated with it. And assuming that that we have enough registrations to hold the program in general, the idea is that would be a full cost recovery registration to pay for the inspection and registration program.
Have we done any research into what that fee might be, or are we still in the planning phases?
So we have, and let me see if I can find it for you.
Mm-hmm.
I don't have a record on this.
And just as a clarification, Mr. Dirk, the registration will be in a separate part of the city code outside of zoning chapter 51.
Yes, that's correct.
Thank you. So, and Commissioner Popkin, just so you have that context, many times we do try to understand what's in the related chapter, but it won't be in our purview.
Okay. Okay. Thank you for that clarification.
And I do have that number if you're ready.
Mm-hmm.
So based on the fee study that was calculated, we came up with an estimation of $197, which would be an annual fee to administer the program.
Okay. Okay. So we're making those calculations. Great. I had one other question regarding exemptions for renting for more than 30 days. And I'm curious how we'll be regulating that. It seems a lot of this structure that we've put together thus far assumes that listings are either listed on Airbnb or VRBO. And I've personally stayed at an Airbnb recently outside of Dallas that had on their door, you know, we've got our own website now, we've got our own 20 listings, please feel free to book through those instead of Airbnb. So I'm hopeful, I guess I should request that staff might reconsider, or I guess like reevaluate the way things are written for other platforms. Is that something that you guys have done? It seems like there's at least one instance, because it appears that this 30-day exemption may only be able to be verified by what's listed on the platform. Is that something else considered?
I think the 30-day is basically the type of rental. So if you are renting in chunks that are less than 30 days, then it's a short-term rental. That's in the definition. The 30-day limit does not limit the number of nights you can rent per year. So it means that as opposed to long-term rental, where I'm renting per month or per year, short-term rental means that I'm renting per night, an unit. But it's not a cap to say that for this property, only 30 nights per year will be used as a short-term rental. Which there are municipalities that do a cap on the number of the stays, basically. But we didn't propose that.
So if you are offering your rental space for at least a month, minimum monthly rentals, the requirement for pulling a permit for a short-term rental wouldn't apply to you. Is that correct?
That's correct. That's a different type of rental. It's not, doesn't fall under this definition.
What is?
Normal rental.
So that's also under code compliance. We just call it a single family rental.
Okay.
Rentals of single units for longer than 30 days.
So that definition already exists.
Yes, and the program for registration.
Okay, so being listed on Airbnb, if you have your listing only available for more than 30 days, your minimum setting is above 30 days, then you would not be subject to needing a permit under what's the way it's been written.
So that would not put you under what we're talking about for short-term rentals. You would still be required to register as a renter, as a landlord for Dallas, under our other.
Oh, okay.
Our other rental program.
Right, we've got that separate accountability program for registration. Okay. Okay, I think that answers my opening questions. I'll give others a chance to ask their questions. Thank you.
It is interesting, though. I didn't know that on the short-term rental platforms, you can do long-term rental as well. I didn't know they offer that too. Do they? Okay.
I've seen that setting, and I know it's possible, at least through Airbnb. I'm not sure about VRBO.
So, and just one question, if I may, in follow up to Commissioner Popkins' questions, how we're defining platforms, it's a general definition, is that correct? Because I know there's multiple entities through which
Yes, I
it
need
is
to
possible.
Push my memory if we have a proposed definition for platforms. And even if we propose one, it's gonna be in the registration, but let me.
And thank you, and that's what, so the platform or listing definition will be within the regulations, not within the zoning, is that correct?
Correct.
Thank you. Did I see? Mr. Reeves, I see you, Mr. Hall first, and then back to Mr. Reeves. Thank you.
Does the city have a revenue target in mind? Where did that 197 come from?
So the 197, so we don't have a revenue target. The program was designed to administer the program. And of course, that's still in development, depending on how ZOAC and CPC and council direct us, right? If it's built as we assumed or as we guessed, with the staffing that we would need to administer the program, we had an outside vendor conduct a fee study that made sure that we stay under the amount that it would cost to actually administer. So it's not a revenue source. It's just paying for the program to administer the program.
Just administrative fees? What about any enforcement fees or inspection fees?
So that's all optional. So it's inspections, it's office staff to receive the application, it's a supervisor, right? The daytime inspections for the initial inspection when you register, the nighttime inspectors for the complaints. So all of that staffing combined, as well as things like the paper and the mailing and all of that, goes into the fee study, and that's where we get the number for one night.
Are you assuming a certain number of short-term rentals would be registered?
So yes, so we did have to have a number to create that number, and this was before I kind of got in the mix, but the number that they used was 3,000.
Okay.
So that's assuming 3,000 people a year register, which I think is between how many are currently registered in PA and some of the larger numbers that we've received outside.
Okay.
Any other questions, Mr. Hall?
Right now.
Thank you. Mr. Reeves?
Oh, thank you. As I'm hearing other questions, I didn't have any to lead off, but everybody's spurring my brain here this morning. So I just heard him say that they were expecting 3,000 a year, and I think I remember numbers that there were about 6,000 in Dallas. So why the only 50% collection versus 100% collection?
I believe we have the city controller with us, Lance or Sherry, and they can explain how they do the hot tax collection. Yes.
Okay, so but the plan right now is that we'll get 50% and we're happy. Is that what I'm hearing?
No, that's not. This is Lance Seahorn. I'm the Assistant City Controller. So the way we identify short-term rentals at this point is we have a service from a company called MuniRevs. I think it's called GovOS now. They scrape all the advertisements through all of the major platforms like Airbnb, VRBO, and those types of entities. And they identify which properties are being advertised, and we bump that list up, or they bump the list up against the short-term rentals that are already registered. And so for the ones that have yet to register, we send a letter to them. We send out letters every single month, and letting them know that that we've identified them as advertising as a short-term rental, and they're required to register and begin collecting and paying occupancy taxes. So about half of them are compliant and about half of them are not. We continue to send them letters every single month. We've also, one of the other options which we have yet to do is to issue a citation. That is a criminal citation rather than a civil citation. So I think when Joey was over the short-term rental task force, we discussed this issue, and he was kind of leaning towards, well, it was still up for discussion about whether or not to issue citations, but that is an option for the city to do. And so that is one thing that may help enforce participation. Another thing would be to possibly enter into an agreement with the platforms for them to collect the tax and remit it to us. So that is another option I think that we've talked about and we're looking at, but no, 50% participation is not our goal. The goal is 100% participation, and so that's kind of where we are right now, and that's how we identify short-term rentals. We do send them letters. We try to get them to register, but many of them just are not compliant yet.
So you did say criminal citation. Does that mean it has to be like a warrant served by the Dallas Police Department?
Well, I'm going to have to let code discuss that because we don't issue the citations here, and I really don't know that much about it. But I do understand that that citation has to be delivered in person. If someone's on code, could you explain that? Because I'm really not familiar with issuing citations.
Mr. Reed, are you able to speak to that?
Well, so I just want to make sure I'm clear. What offense are we referring to?
Like somebody who's running an Airbnb that has not been registered. The statement was that it would be a criminal citation. And my question was, if someone's running an Airbnb and they're not registered, do we have to send the police out there to deliver a criminal citation?
So I do want to make sure I understand it. Is it failure to register under the current hotel occupancy tax registration with the controller's office, or the program that we are proposing with code compliance?
Yes.
I would say
Okay.
both.
Okay, so I won't speak to the warrants. To speak more generally, code compliance can issue civil citations as well as criminal citations. So one of the requirements for a criminal citation is that we do have the person in front of us, which makes it challenging sometimes. So we probably recommend having an option for either one. But I won't speak to the warrant staff, but code compliance can issue criminal citations.
Okay. So a follow-up to Commissioner Popkin, if you don't mind. Commissioner, you said that that on the door there was like where you stayed in this Airbnb or this short-term rental, that it was like they had 20 other properties and they were running their own website basically. Okay, so and I would assume that's a company that's doing that, or if that individual is certainly an LLC to protect them.
Yeah. I would imagine there's some kind of corporate structure to it, but it sounded very, mom and pop, you call an individual. It's still kind of the one-on-one service that you would expect from Airbnb, it seemed like, but they had, a staff of maids that come and clean and that kind of an arrangement. But they had their own website that they were requesting that their renters that would like to come stay here again use that website instead, of course, because they don't have to pay fees to these other platforms. So I think it's important that we keep that in mind, that not especially as things evolve and people move forward, not everyone's going to be listed on one of these two platforms.
Yeah, and you really registered something with me is that yes, there's Airbnb, they're the elephant in the room, but there's VRB, there's Marriott is in this, and now is the city just going to be playing whack-a-mole? Because search engines, Google, I can do all sort, search engine optimization, and with the tools, the plug-in tools, I can start doing a lot of this on my own. So you're right, they don't. If Airbnb is going to supply this information, how many of them are going to be leaking who will not supply this information because we're playing whack-a-mole? So that was my question, and that's all I have until someone else spurs my head. That's all I have for now.
Thank you, Ms.
I'll
Jeff.
also add Hip Camp is another one that's another platform that's being used for short-term rentals, and they initially started with like you can bring your tent and stay on my property, but I noticed recently that there's more RVs and different teepees and all kinds yurts and different things, so there may be an evolution with that site as well. So just to let folks know, there are other platforms being.
Which would be another question. If I had a nice Airstream and I had it hooked up in my backyard, could I, under current code, do an STR with that? So I have a mobile STR.
Did we lose our staff camera?
Yeah, I think we did. Well, hi there. How are you guys doing?
It's a great question, Mark, because I don't think in the way the proposed code's being written that it would allow. I'm wondering what their answer is going to be.
I actually had a guy text me yesterday and ask if he could do that, and I said, I don't know, I don't think so. And he said, well, I couldn't find anything that says you can't. So I'm like, don't go by me then,
I've actually seen them in some other places where they had the cute trailers out back, and that were Airbnbs. I don't know.
So actually, I think we should probably stop talking because we need to be on quorum. Oh, they're back.
And
good.
as you all may have gathered, we've lost connection in the briefing room, so we're working to get logged back on. So we're going to have a brief recess. Please stand by.
Okay.
Great. Finish my breakfast.
Yes, if I
Keep my iPad up in case we need to go to Plan B again on our connection.
I just asked the question about like someone actually texted me yesterday asking if they could do a Airstream in their backyard as an Airbnb or as a short-term rental or a long-term rental for that matter of fact. And I'm like, I didn't know. So, and that was my question. And I think Ms. Bagley had said that she's seen like an Airstream or something like that. We were continuing the conversation before we realized you guys were gone. So I wanted to get that on the public record, what we discussed.
Thank you for that. So I guess, can someone from staff speak to what would, in the current definition, it is a dwelling unit. Would something such as a Airstream on a property be considered a dwelling unit for the purposes of the short-term rental discussion, or would that be something that would need to be?
Oh, I think it depends if that type of structure is allowed in the underlying zoning district, right, Casey?
Yeah, I know we have regulations on, say, campgrounds and trailer parks, trying to find that. I don't know that you can occupy, something like an Airstream outside of one of those.
So.
I think we need to somehow.
Conveyances, the construction level of ordinances. We'll get back on that.
So I think the general, if I'm understanding from Mr. Burgess and Mr. Dre, the question is if it's allowed within the zoning district. And if it is not allowed within the zoning district, then it would likely not be considered as a dwelling unit. Is that a fair assessment? And they're going to review and confirm that that is correct.
And there might be something having to do with wheels, permanent foundation versus not wheels, or something along those lines too. Because there was a guy in my neighborhood that rented one in his backyard. He did it for years.
And is it also correct that per the dwelling unit definition, there would have to be one or more rooms as a single housekeeping unit to accommodate one family and containing one or more kitchen, one or more bathrooms, and one or more bedrooms?
Yeah.
So you have to have those three components to be a dwelling unit. Is that correct?
Yeah, but I think it has to go back to the wheels and if it has a foundation or not. So we need to follow up with Casey and BI. We'll get back.
Well, Madam Chair, if you've ever been in an Airstream, they're nicer than my house. So they have.
Yeah, so
Thank you, Mr. Reeves, for that clarification.
yes. Yeah, so actually I found it. Yeah, so it's chapter 47. So there's a chapter in the city code. It's on campgrounds, house trailers, things like that. It actually says it's unlawful to park a house trailer in the city for human occupancy for longer than 4 hours unless you're in a licensed tour camp or a trailer park. I guess the way around that would be, if you took the wheels off, put it on a foundation, then it was actually a building. But yeah, it sounds like as long as it's on wheels, you probably couldn't do that as an Airbnb.
But you could probably technically jack it up off so it's sitting off the wheels and put a little skirt around it, and then it's permanent.
It has to, we need to loop in BI because it's the same conversation if we can bring anytime we manufacture a house or a mobile home in a single family district. It's basically, it goes back to the building code and yes.
So I believe that comes up a lot with the current discussions on tiny homes. So it'd be good to have that information from BI on how that's interpreted.
Yep. Thank you, Madam Chair.
No, thank you. So I'm going to follow back up as we went offline. One of the other questions was on platforms generally and how platforms would be defined to capture whether it's individual owners versus a company versus groups of owners together. And again, I understand that's going to be within the regulation portion, but that definition would be broad enough to capture however someone might be listing a property. Is that correct?
Yeah, so the way other cities around the country have done it is they've regulated them as booking agents and advertisers. So if someone pays a fee for the listing, it seems like that's the way that they've captured them. So if somebody has their own website or you have somebody that does listings for free, we may have to think of a way to bring them in as well, see if we can. But
Okay. I mean, it certainly sounds like it's a evolving industry, so it's
Yeah.
important to make sure that we had some flexibility in how that is crafted. Thank you, Mr. Burgess. So, Mr. Reeves, was that the end of your questions? I think we had a few others here as well.
Yes, until somebody else spurs another question in my head. So I rely on my teammates here.
Yeah, thank you. It's a good discussion. That's what today is for. Commissioner Boyer.
You you guys spurred me. I was gonna be quiet today. It's your fault, Mr. Reeves. Tiny houses and the code for tiny houses, that if they're using them as an STR, they actually qualify as a dwelling unit if they have the bathroom, the kitchen, and the bedroom, right? So what happens if you have a development that gets a lot and places a bunch of tiny houses on them and then uses them as an STR? How do you capture that? Because it's 9 times out of 10, they're not gonna register with tiny house, because if I remember correctly, our code says that a tiny house, a single family residence has to be one residence on a plat, right?
So it goes back to the definition of single family complex and multi-family.
Right.
So we don't have tiny houses on the land use. The land use is single family, duplex, and multi-family. So it really, like, we need to know what are we addressing and go back to the land use all the time. And even with, so I remember Reeves, now I'm looking into accessory structures. So it goes back to how many structures can you have, or habitable structures you can have, how many dwelling units you can have on your property and stuff like that. Doesn't matter if it's tiny or not. We don't have minimum square footage for a unit.
So
In a zone, right?
BI, that's not something, or building code.
Yes.
So can I? So if we have R5, it says 1 unit, right? 1 dwelling unit per plat, correct?
Yes.
So R75, R5, they all say 1.
Yes.
If you have, what I'm understanding is the underlying definition for that plat defines what is on top of it. And if someone takes R75 or R10 and put 25 as tiny homes on that plat of land, then they're out of compliance because that plat of land says it's 1 dwelling unit because it's R75, R10, whatever, R5? And especially if they're putting multiple STRs or multiple tiny houses on that plat for the use of the STR.
Yes, so a single family use is defined as 1 dwelling unit on 1 lot, which could be a plot, a tract of a plat. If they put multiple houses, just like if they have 1 house with multiple units in it, it then becomes, if it's 3 or more, it becomes a multifamily. Then you're operating a multifamily use in a single family house, so we call that a single family zone. We call that a legal land use, and that would be something code compliance would address.
Okay. The only thing that is allowed is an accessory dwelling unit. It's an ADU that's allowed outside of your house, and that is already regulated in the code. So you can be in a situation, right, where you have, like, I have a single family home and I have an ADU in the back. But the ADU has to either be part of an overlay or approved by BDA. And then you can say that I can rent my ADU and live in my house. Because we need to go back also in the additional provisions for this one. We're proposing to have only 1 rental per dwelling unit, not per lot. So the danger is that you have a single family home and an ADU, so you can put 1 rental per unit, so you can end up with 2. But you cannot do more than that. How many ADUs are you allowed to have in a single family home? Is it just 1? Is it multiple? I'm looking for it right now.
And define ADU for me so that I can appreciate what you're saying.
Yes, let me,
Please.
I'm good to take code.
I'm sorry.
This is a very important portion of the conversation. Because accessory dwelling. Accessory, no, this is what. In rest of all additions, according to the main located on the building side of the city. So that is in the ordinance for the overlay. We have one definition. There are two ways to have an ADU in your backyard. You can overlay, or if it's approved, piece by PDA. For the overlay, we have a definition that says accessory dwelling unit means a rentable additional dwelling unit subordinate to the main unit located on a building site with a single family use. Are we looking to see if it allows more than one?
That's just one, so you could have a rentable accessory dwelling unit. Which implies one.
So you can only have one in an overlay.
And that ADU must be self-contained, meaning it has a bedroom, a kitchen, a bathroom.
It's a dwelling unit, it must comply with that.
Okay.
And there's side list limitations, there's an occupancy requirement and the overlay, and then a registration requirement, is that correct?
For if it's a rental or long-term rental.
Currently, it would only be long-term because that's all we call.
Yeah.
Thank you.
Okay.
I'm done,
Okay.
I'm done.
So I see Commissioner McGregor,
Sure.
or Ms. McGregor.
Just build,
Sit down.
thank you, Tony. To continue to build on making sure that we have all the formats, I don't know if this applies to Dallas, but there are places that rent out, for example, yurts, which are the Mongolian tents or small rooms, and they share a common public areas for eating and bathrooms. And there are just tents out in, for example, in a ranch, I've seen that done, and they're rented for every. I mean, the question is exactly, that format somehow covered.
I would say that it's a lodging or boarding house. So we have it in the code of facility containing at least one, but fewer than 6 guest rooms that are separately rented to occupants. And it says the operator of this may serve meals, and this use may not have kitchens in the guest rooms.
Okay.
So this is a boarding.
So it is covered.
And if it's more than 6, then it's a hotel, again, contrary to the code. So that's the biggest distinction between what lodging uses are in the code right now, which are per room, versus what short-term rental, which is per unit.
So how would that be addressed? So for instance, boarding houses are, I think, and I'm not going to get it exactly right, but they are sometimes by SUP, they are sometimes prohibited. I know in the uses that are currently proposed in our report, if you had what would be considered a boarding house or lodging house, it would then be regulated or could potentially be regulated as a short-term rental. Because if you got the SUP for the use within the zoning district, you could then apply for short-term rental.
Only if you can comply with the short-term rental definition. And I think right now, all of these that are under lodging require a CO. I think that's also important to know. And for short-term rentals, we'll talk about the CO portion.
Yeah.
But I'm wondering.
So in that example, would it be allowed? I guess that's the underlying question. In our current definition as one dwelling unit, this sounds like it would be more like a lodging or boarding house.
Yes, that's this one.
It would not qualify then as a short-term rental. Is that correct?
No, because the definition of a short-term rental is
One
dwelling unit or a portion of it. So I can still live in my house and rent a guest room, but only one, as opposed to this one that says
multiple.
yes.
And with a boarding house, they're not short-term, they're generally long-term.
It doesn't say
It
the
doesn't say.
definition that, I think in a boarding house, you can rent per night or per month. I don't know, does it?
Yeah, it doesn't specify.
What's the code for boarding house? I'm looking it up now.
It's in our, it's
205, 4205. Under lodging is the second.
I'm looking at the, in the, list of.
yeah, it's within a lodging use. It's not within the description.
Page 12.
I see.
Other questions, Mr. McGregor?
No, that was it. Thank you.
Okay, thank you. Other question from our members, Ms. Bagley?
Yeah, I've traveled extensively, stayed in B&Bs in England and Scotland, and they were a different animal than what we're looking at now, because they were 1 or 2 units in somebody's house, and you'd have sometimes a whole street lined with cute little B&Bs. Also, in my zoning experience, I've seen bed and breakfast being listed in zoning ordinances, and many times they're in historic districts or in a neat piece of property or something like that. I know I've looked at Dallas Development Code, and we've never, or at least in my time looking at it, listed the bed and breakfast. But in these other cities that I've worked in or been in, a lot of the bed and breakfast are by SUP. And I've asked this earlier, if this had been considered at all in looking at how to handle these. And I hadn't gotten an answer. So I'd like to
Thank you for bringing that back. We were actually making that note to circle back to that. It's a great segue.
I have a big question I have is, okay, you've said they're not allowed in all these residential districts. How are you going to transition people that have existing Airbnbs, whatever the label is, that have paid hotel and motel tax? What's the process of phasing them out? So first of all, the specific use permit.
So, let me know if you want to
Yeah,
start
please.
the conversation about SUP. So I have been thinking about it for a long, long time. How would we allow it by right? And I think in our first meeting, Commissioner Kingston also asked the same thing. And I think there are a few layers, and it probably merits a larger conversation. What are we trying to accomplish? Are we trying to accomplish another layer of public hearing for all of them, or for in all areas of the city? Or are we trying to look at an SUP as an option to allow short-term rental in single-family neighborhoods? Or we don't know. Even if it's open, it's open. But let's see, what are we trying to accomplish with the SUP, and see if that can also be somehow split with the registration ordinance. That's the answer that I gave in June, and that's still like in my mind. We have to always keep in mind that we are proposing the registration regulation ordinance, and how is that enforceable, and that is gonna be applicable to all of them regardless of the zoning district. And that will contain operational standards and any kind of standards, again, that you cannot amend in any way, you cannot ask relief, nothing. That's a standard you have to basically abide by. And then on top of that, we know that an SUP also has operational standards. What are the operational standards we want to put in an SUP, and why? Also in the registration, and then we can unpack and think, okay, an SUP, the only thing that an SUP brings that the registration ordinance doesn't, is a public hearing. So it's discretionary approval. But we have to keep in mind that even if it's discretionary approval, it's an allowable use. So you have to, if you deny it, you have to demonstrate that it is indeed not appropriate at that location. Another big distinction is SUP stays with the land regardless of who's operating because it's for the use, as opposed to a registration regulation ordinance that's annual registration that's for the specific operator for the specific address. So if the operator leaves, they leave with the license with them. So, and then the length it takes you to go through the SUP process, which is, we know, 6 months. And then we know that exactly that the registration we're proposing for that to be annual. So you have to somehow keep waiting.
The cost.
The cost and even like the practicality of an SUP versus a registration. And again, if we wanna put them together, let's say in a zoning district where we don't think it's appropriate to allow them by right, to basically add a scrutiny for public hearing, we have to keep in mind, okay, let's not overlap what's in the SUP. So we need to make sure that what's in the registration ordinance, how does that apply and what are the teeth? I don't know how to say it more professionally. Which one has more teeth, the SUP or the registration? I think that's what I would like to discuss. But again, we have to keep in mind that the big advantage that an SUP offers is a public hearing. In the registration ordinance, we also proposed for each annual registration to send notification around the property. So that notification is embedded in the registration, but it doesn't have the same weight as in an SUP where the property or the surrounding owners propose, then it weighs a little bit into if I am going to approve the SUP or not. So I would like to talk about these things again, like a regulatory mechanism. Which ones do we prefer? Do we prefer one or the other? Do we want them together and when and why? That's one thing. And then the second thing is, from what we heard from Speaker's Council, was that the problem in the single family residential is the nuisance. And again, we're thinking that the registration and all the operational standards and enforcement will take care of that. But also, we also heard from the speakers that it is a distinction if it's owner occupied and owner operated versus non-occupied, which is something that was a little bit discussed at council. It's a distinction that is made by other cities. So maybe, I don't know if we want to talk about that too, as a somehow another layer. Because the big question is, what are we trying to accomplish with the SUP? And I also did a list and I can show it to you. What are the uses that are allowed with an SUP in single family residential? And there are some uses that are basically always with an SUP. Also keep in mind, currently we have I'll give you a number. I'll look into the table, how many SUPs we have currently in the city and how many will we, considering the fact that we know we have so many operating right now, STRs and thinking.
And so could you just speak to that logistically, and then Ms. Bagley, we'll see if that is starting to answer your question. I think this has likely spurred other discussion points, but globally, what, if the body were to consider the SUPs, what would be the implications of that for essentially administrating? We're talking, so the operation side, the regulations, will include the registration and a lot of the operational components that if then an SUP were layered onto that as well. What might that look like in terms of implementation?
They would have to get the SUP first. So the land use is an allowable use. So first they have to legally be able to register, qualify, or be eligible for registration. So they will have to get the SUP. So it will add a little bit it will make it a little bit more harder on the applicant, right? They have to first come to us, the council, to ask for the SUP. And then after they have the SUP, it's the same with the CO. Then you're eligible to go to Jeremy to get your annual registration. if we have to, so that's the process. And if you're denied, then you're not eligible.
Yeah, we do have one example where we do have something like that as alternative financial establishments, so it'd be like a payday loan places. So we do require SUPs for those, but then we also have a separate chapter of the code that regulates them as well, so.
It's similar to our convenience stores.
Yeah,
We have
yeah,
another-
it's small, yeah, so that's the same thing too.
Convenience stores, there's a number, I think,
Uh-huh.
that may have those. So let me check with Ms. Bagley. Ms. Bagley, and you had a two-part question. We're gonna come back to your second one, but on the SUP, is that, okay, because we've got others who are raising their hands, so I'm giving you first option.
I'm good right now.
Okay.
Thank
And
you.
sorry, want to circle back, presently, we're at number 3,873 SUP numbers. I don't know if they're all active, I don't think so, some of them may have expired. 873. This is what the table, but again, we had an internal conversation, we started to reuse some of the older numbers. I can.
Rough numbers.
Right,
Exactly.
Exactly, so.
Mr. McGregor.
Thank you, Madam Chair. So still on SUPs, I just want to reiterate, or actually have you confirm what I believe to be true, which is there's a significant difference, that's the light difference between an SUP and a permit from the standpoint of the owner. And when I think of, if we were to allow a single family owner to rent their house out when they're not in town, or whatever parameters we have around it, it seems excessive to ask them to go through the SUP process, which also entails a dramatic cost. And in some cases, they'll have a higher representative, and they have to pay also for fees incurred by the city and staff to get there. Where I'm going with this, I think, is that it doesn't seem like SUPs are a reasonable way to control something that can be controlled by permitting. And I'll add one last thing, if what everybody else does is the right way to go, then I looked at Atlanta, San Antonio, Austin, Denver, LA, and Fort Worth is still under consideration, but none of their STR regulations require SUPs. They all go by permitting. I started out thinking we should do SUPs. No, I changed my mind. Stop for that.
Yeah, I looked in other cities as well. I found something in Los Angeles that I'm thinking now to simply just talk to them to clarify, because they don't use SUPs, they use conditional use permits, but I think they're somehow similar. And I think they started the route with conditional use permits, but I think they revised it and transformed it into a home sharing because, and to rely more on the registration regulation, and the way LA does it is, it has to be owner occupied, it's an accessory use to the main use, so they went a different route. But there was something on their website and their FAQ that said short-term rentals are with a CUP, conditional use permit, but we didn't have success with that because they kept continuing to operate without the proper zoning. So therefore, we think that if we simply get them to register so we can regulate them, it will get us somewhere. But I may have misunderstood. I read that FAQ 10,000 times without 3 months, and I'm still a little bit unclear, and it may have what their zoning practices. So probably I'll reach out to them. That's also true. I didn't find too many cities that have it by SUP. It's obviously an option, but I couldn't.
Thank you, Mr. Blair. Mr. Blair.
Along those lines, SUP permitting, but, and I think I am with Mr. McGregor with SUP. The SUP may not be the right pathway for regular, because the use does go with the land. It's set, I can sell it tomorrow. I can, and
Yes.
and I have to go through the process all over again if I go to another location. If it's through the permitting process, then the land use stays the same, correct? We're not making any changes to the land use, but that means Jeremy's got a whole lot of work to do with the permitting process, capturing the numbers know, however they do that, and then regulating the good from the bad. But the question I would have to keep from having to be sitting back at this table again on a 9 o'clock on Tuesday morning is how do we provide enough legal teeth in the process so that it doesn't come back to us? Do we all make it, if you decide you want to do this and it is it's gone through the permitting process, how do, because from what I've seen, our process for permitting and regulating has no teeth. It's either a baby who has not gotten any teeth yet, or old man who's got them all pulled. So how do we get it in the area where the permanent teeth are there and they can bite down and make a difference? Because if we don't put enough teeth in the permitting and the legal side of this, again, we're right back at this Tuesday at 9 o'clock, and I don't want to do this no more. So how do you?
I would say that probably is a question of what is the enforce? I don't know if it's enforcement. If you don't abide by your SVP conditions versus you don't abide by your CO, which one goes faster, and how is the enforcement or the punishment? I wanted to avoid the word punishment, right?
What's the question regarding permitting?
No, my question is twofold. SUP permitting, okay? If you go SUP, it's with the use of the land, and that land use can change tomorrow. If you go, and we're here, I believe, because we need regulations. We're looking for regulations to either deny or allow. And if we do that, and then what is the process in which those behaviors that aren't consistent with a good provider or a good user, what's better? Is it that through the SUP process, and from where in my opinion, where I sit, it doesn't matter whether it's SUP or permitting, we have no teeth.
So basically so if you don't comply with your SUP, what is the route to get them out of there versus you don't comply with theirs?
Right, so what's the enforcement mechanism? What are the penalties? That depends on how we write either ordinance, the zoning as well as the registration under the guidance of the city attorneys. But for code compliance, practically, if a property is operating outside the zoning requirements, we can write them a citation. Right, and it's a violation for every day that they operate that use that we can allege that they're outside of their zone, right? They don't have a CO, or they're in the wrong zone, or they don't have the SUP, something like that. When we come to the point where we can allege that violation, we've given them notice and they don't comply, right? We have the ability to write citations. Now, zoning, we can usually write civil citations, which are faster and easier, or criminal citations if we have the ability. We have the person in front of us, and those are a little more heavy-hitted. The registration potentially is this exact same thing. We can have the same, I won't speak to the levels of penalty because I'm not sure if that's a legal matter, but if we have a registration ordinance and they're operating without that registration, or they're operating in violation of that registration, code compliance can do the exact same thing. But come out there, if we can allege that they are doing that, operating without a registration because we found them on the website, right, or whatever, or they have a registration and they're violating one of those terms, we would then issue one of those same types of citations.
But if so they've gotten all their registration, whether it's SUP, whether it's through code, whatever, and then they become a bad performer, then the problem again becomes whether it's through code in the registration process or whether it's through the SUP in the SUP process. if through the SUP process, if they are a bad performer, we don't see them again until it's time for their renewal. So they could be a bad performer for years, and we won't see that because it's not up for renewal. If, and then only if we get feedback that they have been a bad performer or they brought back before us. And then with the SUP process, you can have automatic renewals. So if they are savvy enough, they know that, oh, if I get I can be a bad performer, but if I get my SUP renewed in timely, I still don't have to come back before a regulating body to provide proof that I'm doing what I'm supposed to do. With code, I have seen enough code violations that have taken years to eradicate. And that's where I'm coming back to saying that even with the code, through the code process, we have no teeth. At the same time, no matter if we're saying we want to allow STRs, if we do, then we need it, and we need to be able to, one, identify the process, and two, if once you get it through the process, identify the process to deny after the fact if the behavior isn't consistent with what we need it to be in order for it to, the STR to be a good community partner. And even with that level, we have to decide and discuss owner operator that is local versus owner operator that is not local. How do you, because like you're even saying, if it's a criminal, they have to be in front of you. If they're not local, they are not going to be in front of you, and they're not going to voluntarily come so you can cite them for criminal behavior.
Right. So just to be clear, this is an ordinance that's outside of zoning that we're proposing. But I do want to be clear about what is proposed, right? So part of our proposition at the City Council was that we build in several layers, right? One, it's registration. It's not discretionary. It doesn't come before CPC and City Council as an SUP would on an individual basis. They either meet the requirements or they don't, right? So regardless of zoning, regardless of whatever. We then issue the registration. They're required to come back in a year. Along the way, you can write civil or criminal citations. They don't have to be in front of us for us to take enforcement, just a certain type of enforcement. But if they're accumulating violations, one of our proposals for that registration ordinance is to be able to revoke that permit after a certain number of violations and or at the Director of Code Compliance's discretion. And then, regardless of whether we revoke it, if they have, I think we were proposing 3 or more violations of whatever is in that registration ordinance, they could also get a separate designation with the City Attorney's Office of habitual nuisance property. So there are several layers of enforcement ability built into the proposal for the registration ordinance.
And another thing that we can do too is if you guys have a situation where you have to revoke the permit, we would probably build into the ordinance as well that you can't get a new one for some reasonable amount of time. I don't know what that would be, but
Or even permanent revocation if they get one and they continuously do or just move to a different location.
Deny somebody's right to.
yeah, but we could do it permanent. But I think we could do it, long enough to where they would feel the hurt, they would want to clean up their act.
But then that goes back to my question, when are we gonna get teeth?
I wanted to ask, the only thing that the SUP brings into this conversation is the fact that operator is gonna be on the public record in the public hearing.
Right.
So it's gonna be it's still in a public record, in a public record with code, but in a public hearing with council, it adds another layer. So you know exactly who's the bad operator by address and by
Yeah, so in either scenario, if it's zoning or regulatory. So yeah, if you have somebody that just doesn't comply, they, code goes out, cites them, and they just keep on doing stuff. But basically, they're gonna get sued by the city, and we're gonna go after an injunction and force them to shut down at some point.
Okay.
So yeah, I mean, there are bad actors out there that just, no matter how many citations they get, they keep doing what they're doing, and then, eventually we'll take them to court.
We just move.
Yeah, they'll move somewhere else, more than likely, yeah.
So, do we have any questions or comments from our online members? We've got one here, and then we do have the second question that Ms. Bagley asked, so I want to make sure we don't lose track of that. Mr. Hall?
Oh, thank you. Yeah, we've heard a lot of stuff this morning. Well, I apologize for my confusion, but very top level, where do we stand right now? The notes I made is that the proposal is to define STR as lodging so that HOT can be collected, to limit STRs to certain zoning districts, and then to establish regulations for the management of the STRs.
That is only for informational purposes, so that is relevant for you to help make a decision when it comes to land use. Everything that is in the registration journal is saying is not subject to this, but I would say, I don't know, please paper. If you say, okay, we want to recommend this to council for that, but I don't know.
So the unknown right now is whether to allow them in residential. That's the bulk of what this conversation is about.
Whether to allow them in residential and which are the districts, which would be the segue to the next point. Like, we have to pick those districts. We propose something, it's only proposed, I have a lot of questions for myself and I don't know.
Yeah, okay, so there's no quick resolution. It's a lot of questions to be answered.
Okay, so which I think partly brings us back to Ms. Bagley's second question, which was, we have existing operators, and has there been consideration of, I know it will be informed by what CPC and ultimately council decides, but how is there a strategy? How is staff evaluating that?
I remember responding to that last time too, and I think it's still open. There are a few ways. One is, obviously they will become illegal if they're not allowed as a land use in the underlying zoning. And as any ordinance, when the ordinance comes into effect, the use is by default illegal. Or there are the cities, they offer the grace period for them to be able to relocate and not stop operation. I don't know, Arlington, I think did it few months, if I remember correctly. So I think there are options to allow them to transition out, but there's no such thing as a non-conforming rights because the land use does not exist. So if you are operating a short-term rental in a single-family neighborhood and council is going to decide that in that zone, or in a zoning district where council will decide that the use is not allowable, the use will become illegal at some point.
Is it also correct? I think this is going all the way back where we started this conversation. We're talking about short-term rentals, or there's still a long-term rental program. So that would still be available. Is that correct?
That's not Massachusetts.
Yeah. Okay.
And I was going to offer, keep on gathering my thoughts, and I realized that I never put in front of the commission a list, or maybe we can look a little bit closer to the ones that we have right now. Are they what's the percentage of them operating in what zoning districts? I know there is a map, and I can share my screen and show it to you on so we can have a little bit of an idea where do they operate. On the memo from May 2021, there is a map that our data analytics department put together.
So I'm sorry, when was this from?
May 2021, when it went to the Quality of Life Committee. It was a big report, the one Commissioner Becker alluded to.
And is that council district, or that's also by zoning district?
It's by council district. So what I will do, I will take the list right now with addresses. I will work with our GIS to see if I can add the zoning districts to see out of the ones that we know are registered with us, how many are in what type of districts?
So again, this would only capture those that are currently registered and paying hot taxes, so it's not necessarily the full picture.
We could get a sample by just going to Airbnb, looking at the things and see.
Yeah, but it's going to have to match the zones.
So we do actually have a list of addresses for active and potential,
Yes,
which I think gets us to about 2,400.
27.
47, which would still give us a good sample and say, hey, what zones are you in? By and large.
That would be nice.
Yes, yes, I can offer that, and I should have put the see how learning.
Mr. McGregor and then Mr. Hall.
Thank you. I have a couple ones. One is following up on your comment about teeth and how important. I think a really important component that needs to be added to that discussion is realizing that some of the owners of enforcement can be and should be put on the platforms themselves. They have the ability to look at 311 data. They of course get information, and they have the ability to just allowing someone from listing in their platform. I think that it doesn't solve the problem entirely, but it goes a long way. And it's much more efficient for the city to help there. The second point that I think I'd love for us to begin to sort of delve into it is the comment about whether STRs will be allowed or not allowed in some areas, specifically in single family neighborhoods. I think I'm just jumping in with an opinion. I've given this a thought. I think to not allow them will not solve the problem, because we already have people operating in single family homes without permits. They're flying under the radar, and we know that the city does not have the capability of through code enforcement or 311 or 911 deal with them. I think we're better off planning for STRs in these areas that create sufficient restrictions so that the concerns that the neighbors have are all addressed. And again, going back to what other cities have done, Austin, several cities have done types of STRs. They do different levels. Austin, of the ones that I reviewed, has 3 types. So type 1 is for STR rules are for owner-occupied properties, and they're the most lenient requirements. I think that there's the assumption that, hey, if you live there, you're not going to let your home turn into a party home. But then they do a type 2, which is not owner-occupied properties, and they're in single-family and duplex districts. And one of the provisions that they created for that type 2 is they limit the number of STRs to only one every 1,000 feet of another T2 or type 2 STR. And then the type 3 is for non-owner occupied, which are in multifamily districts. So I bring that up just to say that the type 3 is non-owner occupied in multifamily districts. I bring it up to say that I think all the issues that have been raised, whether it's overproliferation of STRs, whether it's nuisance and security issues, can be addressed differently in single-family neighborhoods as multifamily neighborhoods with regulations that apply to each. And
Well, does everyone have, or can staff put it on the screen, the list of districts that was our starting point for this discussion? And I guess before we do that, Ms. Bagley, did the response on the question of existing STRs, was that answered, or did you have any follow-up?
I don't have a follow-up, but I'm not comfortable with the answer.
Okay, so we'll send additional questions to staff then on that. Okay. And so the question from Mr. McGregor was, in thinking about districts where this use might potentially be allowed. And so we have a list that was given to us in our appendix by staff. Generally, and Mr. Drea, correct me if I don't capture this, the table reflects location districts where lodging uses are allowed as permitted generally. And then there's some nuances I think in there that might come out of this conversation. That was the general approach. Okay.
So I chose to share the slide from the PowerPoint because it also includes the residential uses. I keep on going back to that dwelling unit, because dwelling unit is obviously residential. So I'm thinking that this is something that I'm circling. I don't have an answer. when we're picking, based on obviously make an informed decision, you are picking, make an informed decision on the districts, I think the fact that it is a dwelling unit essentially may play a role. If you want that. So that's what I mean by the residential uses. And I included, I didn't, for single family, obviously, I can widely stable as much as possible. I didn't put single families.
Understood. And then just for reference, in single family, essentially our districts are prohibited: agricultural, duplex, townhouse, cluster housing, and MF1, because that did not include, those are the ones that aren't on. Is that?
I included MF1.
Oh, you did, thank you.
Yeah, but I didn't, in our very drafty first stab at it, it's not, any lodging use is not allowed in MF1, and we're not proposing. I am very hesitant with the proposal because I don't think it's a proposal, it's just opening up the discussion.
And so, and thank you for including the lodging uses, because I think that's also helpful. So for instance, in MF districts, the allowed use is a lodging or a boarding house. And is it correct? And also thank you for including the definitions in our case report. It's 6 or less rooms versus a hotel, which is 6 or more.
Yes.
Okay, thank you. And so I guess initial thoughts. I know we've been talking a lot here in the room. Anyone online? Don't want to lose track of you all. Okay.
Just point of clarification.
Commissioner Popkin. Yes.
Thank you, Chair. So I don't see single family uses on here.
Correct. And so that's what we were just saying, is that if you look in our case report on page 9, the residential uses and the proposed conditions were not allowed, so they weren't included on this chart. But again, that's obviously something this body, and I think Mr. McGregor was asking that question.
Yes, and I heard Dr. Udrea mention that there are a list of potential uses that are available by SUP in single family residential. Could we get that list as well? Or do we have that available already?
That may need to be a follow-up, or did you have that we could?
I created it as a draft for us as a support for today's discussion, so I can share. But it's that's why, like, if you give me a very clear direction what we want to achieve with the SUP, I can drill and somehow adjust it. But for now, what I created is a list of uses that are allowed by right in the single family districts. I'm sorry, like I'm trying to.
While she's looking at it, could I ask a quick legal question? My understanding is the city has the right to change zoning ordinances.
Correct.
And once that change is made, there's no grandfathering in to avoid those changes.
Yeah, so if you were.
Looks like we lost City Hall again. We can see the screen
noted
moving,
that
but we
when
can't
they
hear
start
that.
to appear from less intensive single family to more intensive single family. So a convalescent nursing home is only allowed in TH district. Anyway, it's not allowed in R's and P's, right? None of the lodging uses are permitted, and then recreational uses, retirement housing shows up with an SUP above TH density. And then transportation utility, they're all kind of like the same. And then there are some accessory uses. For instance, accessory community centers allowed by SUP in the single family districts. So this is the list of SUP uses allowable by SUP in these districts, not in the ones where we're proposing to be, the short-term rental to be permitted. So I didn't overlap, and I can, again, but I need to understand where we're in.
Well, to go back to, I think one of the other questions that Mr. McGregor asked was about this question between owner occupied and non-owner occupied. Is that an effective mechanism? I think there are some municipalities that have taken that route in these two types, or however they define their various types. But how do you define what are there common measures that are utilized to define owner occupied?
There were, I don't, where I look sick. So Casey can speak about Austin, because every time you say Austin, everybody knows about lawsuits and stuff. So I would let Casey talk. What was the issue there? So Austin has it like that. San Antonio has it like that as well. Type 1 and type B, owner versus non-owner. And they do have a definition, but I found other definitions outside of Texas. It's basically looks in, it is the primary residence where the resident lived there for whatever period of time. There are cities that say 6 months, there are cities that say 1 year. So I think we can define that. I don't know, I would leave it to Casey if that is suitable for the land use portion, probably, or the registration. I think we can do whatever.
Yeah, probably either way. And yeah, and she mentioned Austin, so I got Austin in trouble when they did the type 1 and type 2. They didn't articulate a land use rationale for making the distinction. So if you guys are thinking about doing that, and say just be sure to make an articulation, put it on the record. I'm sure you guys can come up with good reasons for treating the two differently.
I'll just observe, I think we've heard some testimony that perhaps, and we utilize this, ADUs are a good example where the owner being on site, serves as essentially an enforcement mechanism. That there's more accountability, you know who to call, it's your neighbor, and
you'll know when they register, if their driver's license has that address, it's a good, pretty helpful way to say that that's probably the primary address.
But is a driver's license, for instance, something that would be, I know I've heard discussion on whether it's a homestead, what would be the types of, and would that be within the zone? In other words, if zoning required a home owner or owner occupancy requirement, where would those provisions be captured? Would that be within the zoning or would that be within the regulations?
I think we said either or, that's what he said.
Yeah, I think you could put that either one. Yeah, look at our residential uses, sort of like our additional dwelling units, because I know we do say that one has to be occupied. I don't know if we have anything in there that talks about what that means.
Yeah. So as we're looking that up, are there other thoughts or questions on the current discussion point, limiting districts, but also the question of owner occupied?
Are we able to send messages via the chat to the council so that you guys have written questions that you can respond to in some form or fashion?
Who's speaking, please?
My name's Kiwi Hendricks.
Sir, this is a meeting for the ZOAC members and for staff. You are certainly welcome. Anyone who is online is welcome to send communications to Arturo del Castillo, and those can be shared with all members and staff. That's open for anyone, any members of the public who are here with us today.
So going back to the previous question, looking at the accessory dwelling unit stuff in the code. Yeah, it does say if you're doing an accessory dwelling unit, one of the dwelling units have to be owner occupied, but it doesn't give any sort of criteria for measuring what that is.
Okay, so that
here.
It's really important. If the body were to consider it, that would be a consideration then.
I want to make a very important comment regarding zoning versus registration. Please keep in mind that Chapter 51 is open to amendments via PDs, as opposed to registration ordinance that is not. So if you have stuff and requirements in the registration ordinance, me as a property owner, I can come and ask for an amendment because I cannot comply. But if it's in the zoning, I have the PDD to do that. So always keep in mind.
Oh, you said a mouthful. Now can I ask a question? First, let me reiterate what you said, so make sure that everybody quite gets it. In a zoning change, an operator can use the tools that we have in zoning, i.e. a PD, to tailor their STR so that it can be in compliance without changing a behavior. And if it can get it through CPC and council, then that PD becomes an ordinance and we can't change it.
You can change it with the powers of council.
With the powers of
Obviously,
council.
but we have to keep in mind.
But it's not easy.
It's not.
Okay. Through the ordinance, not the ordinance, but the registration process, the ability to do that, one, to make those change, to make something comply by a PD does not exist. Correct?
How do you amend the registration ordinance?
Yeah, correct. Well, that would have to be, generated by, whatever committee, city council, or I guess staff could take an amendment, but yes, remember the public couldn't come in and make an application to change the ordinance. Yeah, that's not
Or to
possible.
make it applicable only to their property.
Yeah, you could do that with the BDA, right?
It depends on how we write, because BDA, it's also in 51A and 51, so it depends on how we write it.
So that would be similar, and again, just as an example, since we've talked about accessory dwelling units, that you can go to Board of Adjustment to request for, and that's just, for instance.
That's how it is.
Yeah.
Okay.
You better than I, that's.
So any other questions on, districts, owner occupancy, Mr. Reeves? And I'm gonna if you'll give me one moment, I just want to do a little time check for us. We are at 10:34 a.m. I think our meeting time was, we left it somewhat open-ended, but do want to be respectful of all of our members and the members of the public with us. So, we might be starting to think about sort of direction for staff and where we'd like to see this when it comes back. So with that, Mr. Reeves.
Yeah, so a twofold question. I'll open up the can of worms, I guess. To tag team on Commissioner Blair's earlier thing, how in the world do you start enforcing owner occupied? If there's 3,000 or 6,000, however many, and you start, is it your driver's license? All right, well, I can just go down there and tell them my driver's license. I own this property. I can say I live there now. Please show up. There's no owner there. And my other question is, I know that the courts have upheld the zoning side of this as legal. Has anybody challenged the owner occupied? Because a corporation is a person. And if a corporation is a person and they have a person, that's supposed to be there, then, what kind of can of worms are we opening up at that point with this potential owner occupied? We have a hard enough time enforcing things now. How are we going to enforce this?
Isn't the onus on the owner to provide documentation that shows it?
To obtain a license.
To obtain a license, right?
But
So-
they've obtained the license because they own it. But how do you ensure that they are occupying?
But it's up to the owner to demonstrate that they occupy that place. So whether it's showing utility bills, a combination of things, certainly the address on their government issued IDs. I am sure that a very fancy structure with someone that has a Cayman Island holding coming out, some will get through with this, but for the most part, you should be able to capture everyone. Yeah, I can't think of an example or something.
I would go back and ask you, the issue again is nuisance, and basically we want to make sure that the owner lives on site or is present on site because we want somebody to be responsible and eliminate the nuisance, or what is the issue? That's one. And second, promise I will talk to San Antonio to see how they do theirs and have a lesson learned from somebody who's doing it.
Okay, so, and I guess, Mr. Burgess, if you could help us understand essentially how this has been considered, if it has been considered.
Yeah, I'll just see, I'm not aware of any challenges to, the owner occupancy part, but I'll do another look to see if there's anything out there, but yeah, I'm not aware of anything right now.
Like, Los Angeles, Denver, New York, they do have provisions regarding the Atlanta, that it has to be owner occupied. So they do use this route for a couple of years, but for the local ones.
I think that would be helpful for the body to understand how that's been considered and what's been affected and how it's defined. I guess if we go back to the district question, I know there's been a lot of discussion around the multifamily and how that was considered. So in our, draft list that we have, multifamily is showed as allowed, but that could range everything from a 4-unit complex to a 200-unit complex. And, I think we've heard some testimony that that's potentially more intrusive. You don't even have a side yard separation. It could literally be on the other side of the wall. Was that anything that staff had evaluated and considering?
Right, so we were talking in the last 2 meetings about a percentage for multifamilies, to put a percentage of how many units can be used as short-term rentals. And I don't know if we had, I think we started with 10%. And I remember the committee giving us direction to see, mixed use project, where can we find, because I need some guidance. I was thinking right now that since we're trying to somehow look at how a boarding house, lodging boarding house, and that's 6 or less, 6 is also a number that's in the code. But we will have to have a religious rationale to cap the number of units, is it by percentage of by units in a multifamily.
I'll give an example. We received a letter from a community member who was aware of an apartment building in their community. I believe it was 8 units, and the entire property was being listed as a short-term rental, which would functionally seem to be operating as a hotel at that point.
Yeah, because it's above 6. So I'm thinking we can try and operate with what we have in the code, which is this distinction by 6. It may be 6 or 10%, whichever is less, to capture basically a wide array of types of multifamily.
And that would be more consistent with the allowed boarding house use that's essentially generally allowed. But again, it's a more limited versus the higher unit.
Thank you, Madam Chair. I actually want to add to that. And I think this is a point that a friend of mine brought to me, and I think it's very valuable, which is we look at the concerns of nuisance and security, but there are broader concerns related to STRs, which there's several sources. Again, this friend is in the body Clark, said a lot of research. He sent me articles from nonprofit organizations like National Low Income Housing Coalition, academic institutions like the University of Massachusetts, UCLA. I wrote them down so that University of California, and also the National Bureau of Economics. Through our studies, these different organizations have noted that an over-proliferation of STRs is associated with higher property prices. It exacerbates the affordable housing prices because, of course, it takes up supply. It drives up rents by increasing rental supply. This, I think, really important. In the apartment example that we're talking about, it has a financial impact on schools whose funding is based on number of enrolled students. And finally, they've also found an increase in crime rates, not related to an individual bad operator, but attributed to the weaker social fabric in communities where there is an over-proliferation of STRs. I'll send links to all these articles so that they're on the site. So I do think that a guiding principle of, as we look at restrictions for STRs, needs to be that while they are allowed, we need to be very careful that they don't take over the community, because there are longer term and broader concern implications. And we know that STRs are growing at a fast pace, right? So this is the time to go in and put the brakes on it, and I think while allowing them just protect them. That wasn't a question, wasn't it? Thank you, Madam Chair.
Well, and I guess just to expand on that, I think one of the recurring themes on those who are concerned, I think spoke about noise, the number of occupants, which we haven't touched on at all, how the implication of light, odors, noise, parking that we hear about, particularly again, goes back to occupancy. And I guess I'll just ask the question. I don't see anything in the current definition as proposed. It's one dwelling unit, but how would occupancy be considered for that? I think we've heard lots of testimony. There's been news reports about, hundreds of people, 20 people, groups that are larger than would be expected in a typical, millions of residents, but even in a multifamily property. Everyone's suddenly out of the pool. I mean, how would that be considered?
Yes, so the thought on that was we would more than likely put that into the regulatory ordinance and mirror the language in the Texas property code that says if you're renting out a property, you can rent to 3 adults per bedroom. So we've already got a basis for that. That's the state law. So that's something the courts likely uphold, and we'd be able to defend.
Okay. And so then it would go back to the number of bedrooms. And we
Correct.
just reviewed our bedroom definition.
No, it goes back to how many rental you can have per dwelling unit, which is 1.
Right, but if you have 1 dwelling unit and you have 5 bedrooms,
it's still 1 rental.
Oh, no, because you can rent it, you can rent out.
Yeah, 18 adults. 15 adults.
Commissioner Boyd?
Going back to that and our parking, because our parking, our zoning and parking is now being impacted if you have an STR that is a high user, and we're only offering for single family a 2-car garage and one parking space for 1 street parking. And if you're looking at multifamily, and what is it, 1.5 per dwelling, was it 1 per bedroom? So, and if you have a 3-bedroom and you're putting in 6 people and they all have a car, then you now have, so the question is, how do we define STR and change and when it comes to parking, our parking regulations? Even if we don't want to say it's a zoning matter, but a regulation matter, it's now impacting a zoning regulation.
We propose 1 per rental. So that's in addition to what you have for your dwelling unit. So if your dwelling unit has for code 2, those are required. If you want to rent, you're gonna have an additional one. So that's what we're using. But again, it's open for discussion here. Also in the registration portion, and I think that's very, very important, we had a requirement that available parking must be listed on the listing. So if we run into issues, you as a renter would know, you'll know that, oh, I'm coming with 20 people, I don't have enough parking. And then I'm hoping it's an enforcement, like if you don't, like it happened, and then you come back, it goes back to you were a nuisance.
So
So you were violating.
may I, Chair? So if I am renting out a facility at my house and I'm going to have 40 people at my house for that, at that particular facility for that day, then I become a nuisance because I have all this parking requirements that my community can't handle. But on the same token, if our ordinance says it's however many plus one, and I am a STR in a single family, and my STR can't park 10, then I become a nuisance. So then the question I ask not only staff, but ZOAC is, does that answer our own question as to STR's regulations from a zoning perspective as well as a regulatory perspective, if our zoning code automatically denies automatically makes it a nuisance based on the existing code, i.e. parking, that says, I can't park you. Even if I'm a multifamily, I can't park you because when you go to get when you go to BI to get your permit to build, it's based on the inherent use. And then after you've gotten your build, you've gone through BI, you build your facility, and you change the use from its intended, then you automatically become a nuisance because you're out of compliance with another portion of 51A that says you can't park. So how do we manage that? You just looking at me and
Yeah, you've actually thought about that. Andre, are you guys still proposing the event venue use?
Yes, so we do have the third additional provision. It says a short-term rental must not be used as commercial amusement inside, outside event venue, and we're gonna come back with a proposal for an event venue new use. Restaurant or any other uses unless located in a district in which the use is permitted and has a certificate of occupancy. So this was in an attempt to address the party houses issue. Now, as to I think what the nuance that I got in your statement was if me at my house. So if me at my house have a party and like my guests come by car, it's a nuisance regardless if I'm a short-term rental or not, right? I don't know if, so it's the same issue with anything that.
But the difference between an STR and I just have a party at my house, I don't have a party at, but with one would hope as a resident, I don't party every day or I don't party every weekend. And if I do, maybe I should move my party from my house to another party. Yes. So if I am an STR and I do this I do this either on a regular basis or enough that I become a nuisance, how then do we regulate that with? No, but see, again, like I said, I've impacted my zoning because I'm not I'm not parked correctly as per zoning ordinance and my use.
I think I am part correctly because the zoning is still gonna require one per unit, let's say, or whatever we decide, you decide. A nuisance is a nuisance.
Right.
Like if you park on the city street and you park three in a row where it's too loud, it's like.
Clarification, if it is allowed in MF as currently proposed, and then multifamily project is required one per bedroom, and then we put a cap on however many it could be, and you've got to have 6 more parking spaces. If you don't have those 6 additional parking spaces, you could not get a permit. Is that correct? In other words, if you can't prove that you have the available spaces, then you would not meet the zoning requirements, therefore you would not qualify for a permit. Is that accurate?
Yes, but it goes back to what is your requirement. I think that's where.
And again, I'm understanding
There we go.
Commissioner Bear's question, is the number listed correct? Should
Yeah.
it be thought of differently? I understand, and again, but I just wanted to make that clarification.
Yes, that's right.
And I think the way we would handle the situation you're describing is we come up with a separate use as an event venue, so that's to handle that type of situation where somebody's renting out a house, or, you know, it could be something else, but yeah, they're renting it out for that purpose to bring a lot of people in, throw a party, wedding, reception, whatever. So in that case, you know, once that use is established, somebody did that in a short-term rental, that would be an illegal land use. And yeah, they would get in trouble with code and potentially get sued on that,
So yeah, I want to bring it back just quickly because I know we are starting to lose some folks. We have our district listing that is in our case report. I think our focus has been on the residential districts. In the proposed non-residential districts, are there any comments from members in those? And I can read them as helpful. It's on page 9 of our case report. I think Mr. Dre is going to share the screen. I just want to get a.
And I can guide a little bit the conversation to. The definition is dwelling unit or a portion of it. And there are some districts in here, maybe if we want to have a separate conversation about MF and use. And there are some other districts like the one that are industrial and commercial that do not even allow residential use. So, although again, I didn't see any city that did that once. I'm having difficulties to understand how a short-term rental would even exist in an IM where any residential use is not allowed, so a dwelling unit can't happen. So, and I'm still trying to understand that. So that's something food for thought on how we're putting the districts.
Okay, so for instance, I'll use IR. So IR currently allows a hotel, but it also, no, it does not allow multifamily.
Even if it allows a hotel, but it doesn't allow any residential.
I was gonna say no multifamily, and so those may be 2 that aren't necessarily needed because.
If you look on the screen, you see all of these districts and even a little bit of RRCS, they don't allow residential at all. So I am having trouble understanding how a dwelling unit can ever exist in there unless there's already existing and non-conforming. And if the short-term rental exists, then they automatically can transition to legal use, but it's very hypothetical. We're still thinking, we're talking about it, but maybe you want to think about that too. That's the reason why I put them together, to show this.
Can you redistribute it as maybe just this slide to the bottom? I think it's posted on our webpage, but it might be a good kind of quick reference for us all.
So, and then, for instance, another comment I would make is, we all know that CA is downtown. I don't think we may have few PDs that are defaulting to CA, but CA is mainly downtown. But MU,
What is CA?
Central area. But MU, which is mixed use, is a zoning district that was introduced in our code a little bit after the code was created, so it's a newer zone type of zoning district, meaning we never zoned big chunks of the city. So I cannot say usually AMU is in Uptown or in Denver. We have seen, so therefore, in order for you to have an MU, you have to rezone to an MU district. So we may have areas in the city, and I can do a study, a land use study only on MUs. But where I'm getting at is if you're commissioners, you know that we may get a request for an MU in a single family neighborhood or in a IR, just so they can do live work units or other stuff like that. So we may have MUs somewhere in single family districts, and then thinking of intended or unintended consequences. If a short-term rental is allowed in MU but not in single family, are we gonna see more general zoning changes for MUs? Are we gonna deny more general changes to MUs because we know that short-term rental is allowed? So that's the type of thinking when picking these districts, to use our experience of this CPC.
But is it fair to say that the MU districts, as much as you would have to rezone for that, there is a required mix of uses and there are other development requirements that address adjacencies?
You can do a multi-family in an MU.
Agreed.
Just that, without being, it's not, if you want to build in an MU, it's not a requirement to be an MUP, a mixed-use project.
Okay, good clarification.
So yeah, you may end up trying to want to rezone to an MU just to get short-term rentals. So yeah, I think in terms of the zoning, obviously we're addressing a trend that we're seeing with this use of additional land use, but also let's use it as an implementation tool as well.
And so MC is multiple commercial, IM, industrial manufacturing, IR, industrial research, LI, light industrial.
Yes.
CS, community service.
Yeah, it's a
No, it's, well, community service, neighborhood service.
commercial service.
Commercial service, thank you.
Very intense. It's a very, very dialed down version of an industrial district in my.
Right. RR is regional retail. And so again, none of these, I'm trying to look, well, two of them have college dormitory, fraternity or sorority house.
Yes, so basically you can turn a college dormitory sorority house in a short-term rental. That's the only, I'm trying to again, but keep in mind also, like, I've looked in a lot of cities, not all the cities obviously that do regulate short-term rentals, all the definitions include the word dwelling unit. So I couldn't find a definition of short-term rental that is not tied to word dwelling unit. So basically, it's still I am sharing my house.
Or a multi-family project.
A house, it's still a house, like it's still a dwelling unit in a multi-family. So I don't think these are like zoning debates.
Questions? So, Mr. Reeves, thank you. I'm trying to get some notes to give some direction, but please.
So a question really quick about the multifamily. I liked your, Madam Chair, I liked your comment about, well, if it's a 40 unit multifamily and everyone's an STR, that's really a hotel. And in my mind, even if it's a 6 unit duplex or triplex or something like that, and every unit is rented, then that's a hotel too. But I do have a question. So in our base code for multifamily, we do provide a density bonus for affordable housing, correct? Question to
Yes,
staff.
we do.
Okay,
Yes.
so what's to prevent me from getting my density bonus? So I get, reduction in parking, I get a high, higher, whatever have you. And then I turn around, which is supposed to, I'm getting the density bonus for affordable housing, but then I turn around and I do STRs. So I've actually gone contrary 180 degrees to why I had the density bonus in the first place. What's to prevent that?
The units that are to be used as affordable units for chapter 20, they cannot be used as short-term rental. I
Okay,
checked
so
with the
let's
housing.
say, so let's say I get 10 units for affordable housing, but I turn around and I do 20 units of STR, which is now taking those units away from other people, basically shrinking the housing. So yeah, I'll give you your 10, but now I'm gonna take 20.
And again, let's not forget, we still are proposing a cap on multifamily, but we don't know what the cap looks like. Is it, and what I was thinking out loud earlier was maybe we can embed the 6 with the 10% or whatever percentage we want, and we say whichever is less. So if you have a building that has 6, 10% is 0.6, so it's 1 unit. So we can play with these numbers because we already said that we can put a cap. The big question that I have for you, the way we propose it right now is in the registration portion, so it's not amendable. Do we want to put it in the zoning portion? Or do we want to put it in, if we put it in the zoning portion, we're gonna have to make a land use rationale, we'll come up with one.
Did that answer your question, Mr. Reeves?
Yeah, and I think we have to be very cognizant of that because we would be killing exactly what we were giving people potential bonus densities for affordable housing to do, what we're trying to encourage. We have to make sure we keep that encouragement.
So along the line of what Mr. Reeves is saying, if we are doing a mixed use and then get the density bonus, small reduction in parking, but then they make a percentage of it affordable. And I understand those affordable units cannot be STR. How do you regulate it?
It's by the affordable units cannot be STR. It's already in chapter 20. Which is a separate chapter of the code, and it's in there, and it's specifically said that you cannot rent it out for shorter periods and stuff like that, and even subleasing. So if that's been again taken care of by housing, but they do it with these restrictions, from what I know.
But then, yeah, how many abide by those deed restrictions, right? So, but then also with the reduction of housing stock, is it beneficial to think that if you're getting any kind of bonus and you maybe should not be eligible to use any of that as an STR because you are utilizing bonuses that remove housing stock? Or you're providing housing stock limitations? Or is it something we can't legally do?
Oh, I would invite Pat next time. I think the intent of the mixed income housing bonus is obviously to secure affordable housing, but to also increase density and secure more housing.
Correct.
So I would hate, but right now I'm assuming. I would hate to scare the bonus. So I would hate for a developer to have to choose between 6 units of short-term rental and 6 units of affordable and say, no, short-term rental gives me more money, so I don't need your bonus. Because with the bonus, you get more units overall, but you also get some affordable units. So I would think that since the mixed income housing bonus is a bonus, not a requirement, and we're trying hard to get more housing and more affordable housing, I would hate to penalize and single them out to say, oh, by the way, you cannot do short-term rental. If you want to do short-term rental, do it by code. And again, at the end of the day, it's a question of math for a developer. But from a public interest,
but does it not lend itself to ask if the developer is getting a bonus affordable and using it as affordable, knowing that they're gonna get a higher percentage that they can do STRs on and not even tell us. And then you get the bonus, you get the higher density, and then take that advantage to their advantage and to our disadvantage.
But again, what is our goal? We want more units, right? So the density is not for the developer, the density is also for the city because it translates into more units.
But we want more units that are for residential use and not for business purposes. And business purposes, there's a STR. And you're taking the bonus, you're getting you're giving up the affordability, but you're getting the more units that you're not really truly putting into the stock, into the whole purpose of getting those additional units. So we still need to go back and then build more housing stock because we gave this bonus to this mixed use developer who didn't use it appropriately.
Yes, I understand. I have, again, two fixes. One is we can put a cap to say, again, percentage of number of units, whichever is less. And then I think that will somehow, you'll have to build in excess and maybe he builds 20 in excess and the cap is less than 20 units.
But it's still saying, I'm going to encourage STRs because in a mixed use development, because I can get more units, and the more I build, the more I get to have as a STR because it's a matter of numbers. If the percentage is 10% and I build 1,000, that's a whole lot.
It says that 10%, but maybe put a number. The number maybe 6. Going back to the boarding house. And then my other observation would be short-term rental is a temporary use. It's not, the building still remains and it may turn back to its use as a dwelling unit.
Oh, I think I get it, because you're saying the number of 6 is, if it's more than 6, it's a hotel, and if it's less than 6, it's okay, I see where you're whichever is less. 6 or whichever.
And also can keep in mind that maybe the trend slows down with Airbnbs like it happened during the pandemic. It can always go back to being used as a dwelling because it's still the building exists to its first intended purpose, which is residential.
I'm going to try to summarize. If I may, I have 2 final questions. On the short-term rental definition, it is proposed as a full or partial dwelling unit that is rented to occupants for fewer than 30 consecutive days per rental period. Was there any consideration of a minimum period? Minimum. In other words,
okay, it's in the registration. It says
Two days.
okay, and are the registration that's in our June 23rd? Is that correct?
7th into July 7th, and it's on my screen.
So
It says minimum nights.
It's not in the August 2nd. That's what I didn't go all the way back. Thank you.
Minimum night stay of not less than 2 days. So that means that it's 1 night, right?
2 days. Yeah, you have to say at least 2 nights.
That's just a language clarification.
Yes.
Yes, 2 nights.
That's, yeah, you cannot.
Friday night and Saturday.
Yes.
Can't
So the STR, you have to stay 2 nights,
Right? Minimum. So it's not by hour.
but you can't rent it more than 30.
Well, the thing is long-term, quote, long-term.
You don't, so it's a minimum of 2 and not more than 30.
Or less than 30.
It's less than 30.
If you're over 30.
You're
it's long.
hotel.
It's a different type of
Okay.
contract between me and my renter, right?
Okay. Oh, Commissioner Popkin.
Yeah, I'd like to make a point of clarification. I know often sometimes often. STRs can be rented for short-term uses, and sometimes guests request to stay for longer periods. So I'd recommend that we identify STRs as accommodating uses that are less than 30 days, but not limiting it to uses under 30 days, because there are people who are going to want to rent for a month or two, but it is still, I would recommend that it is still considered an STR, even if there are occasional longer uses.
Yeah, if they can.
Would there be, it's simply saying if it is less than 30 days, it falls under this classification. Is that correct?
Yeah, me as a person who wants to rent, what if I want to rent this type of accommodation, but for 2 months? I would still pay per day. That's the, I think it's the payment, right? And I don't.
Does that address your question, Commissioner Roberts? I don't think it's saying that it's limited to 30 days, but if it is available for less than 30 days, it is considered an STR.
Yes, yes. Just wanted to make sure that was clarified, that we're not leaving out folks who also rent for more than 30 days and putting them in a different category.
Yeah, we're going to ask staff to clarify that. And if there's any clarification in the language.
Yeah, so I think the clarification we need to come up with is, we have currently in the definition that is rented fewer than 30 consecutive days, not what is listed. So they could, if we keep it like that, it's hypothetically possible, they could say, well, nobody's ever taken me up on less than 30 days, right? And try to make a loophole. The other side would be to say, if they offer anywhere from 1 day, 2 days to a year, right? We would then have to find out what they are doing to see which program do they have to register under. Because hypothetically, they could rent for 2 days, 1 month, and then 60 days right after that, and then go back to 2 days. Right? I can kind of clarify what's on the listing, what's the practice, and then, of course, on code, how do we determine that and then enforce it?
Okay. So, clarification on period. Mr. Rivera.
Yeah, I think we're just adding requests, right? So I think that's right. One that I saw it on the LA STR ordinance that to only hosts on approved platform, approved by the city, and can operate. And this is what the owners of the platform to ensure that we understand that. Do we look at that in here? It's not a regular.
I think that's what we were looking into, a platform regulation that's separate from zoning.
Okay.
I think in the platform regulation, we say, it's a little bit here, require platforms to remove any listing that is not licensed, require platform to provide location being listed, hold the platform accountable for failure to comply. So I think we were thinking always to have regulations for platforms.
Okay, perfect. I think I have one more thing. I think this goes back to the types and what goes with the types of the first to that. But I wouldn't mind beginning to crystallize the conversation into whether or not perhaps staff proposing types, if you were to.
Let me see if I'm ready. Mr. Hyde, yes.
On the platform regulation, are you going to stipulate that the platforms collect the HOT at point of sales?
Is that where we ended up on? I forgot what.
Require the collection.
Yeah, we really are, collections people are waiting on that, that's something you can require. That's one I'm not sure on.
But is that within zoning or within regulations?
That would be regulation, that's part of the zoning.
Oh, okay. But it would make it easier, I suspect.
So final question, would it be appropriate in zoning to require that the short-term rental permit must be secured prior to operation?
I think we have it, I think we already have it in there, we said we have 3 additional provisions. The use must comply with chapter whatever, short-term rentals of the
So then that's back into regulations.
Registration regulation ordinance, so we say that the use must comply with it. It's in the zoning, you cannot, and then whatever is in that.
Oh, yes, sorry, I'm back with you. That's the first sentence.
Yes.
And the additional,
So we have 3 additional provisions.
use must comply. And then with that compliance comes the permit.
Yes.
Okay.
Yes.
All right, and then the additional, the current draft, number of short-term rentals in a single dwelling unit may not exceed 1. And then use of the short-term rental must not be used as the commercial amusement and the other ones. So essentially the party house.
Yes, we will come back. We presented to council the idea that we would come back with creating the new land use that's event venue. But we didn't want to do it in the same time. So after this, we're done with this second code amendment, you're gonna see it's gonna address event venues.
So my final question is, I think we started this by saying that there needs to be a land use rationale in including this. Is that appropriate to include, as we do with many of our districts, essentially what's the purpose? Should that be something that is considered as a part of this?
I like it, but attorneys have a different opinion, but I like it as a purpose.
Yeah, I mean, I think you could include, either a purpose under the use, or, we could include a lot of whereas clauses in the ordinance that gets to the same place, explains why we're doing this.
And so is that, okay.
Yeah, the Arlington ordinance, all the ordinance that I read, the registration regulation ordinances for this being land use or just registration had in the whereas clauses a lot of policy directions.
That may be helpful to give context to what we're considering here.
Yeah, that was actually one of the downfalls lost, is they didn't have that, so that would be something I would definitely want to include.
Okay. All right, so members, I'm going to read what I think I've captured from today's discussion. If I missed something, let me know. So I would suggest that we would hold this matter under advisement until our August 18th, 2022 hearing, and direct staff to respond to the following. To distribute a map of locations of listed and the 2,700, I forget what
The
the
ones
other
that are
term is.
registered with us.
The registered and the understood to be STRs, that we would bring forth proposed language for a multifamily cap as discussed, to consider a maximum of 6 or a maximum or 10%, whichever is less. That we would have staff bring owner occupancy provisions, including typical provisions from other municipalities, metrics that would establish occupancy requirements, and also how this would be considered under state law. That we would look at the definitions within zoning regarding occupancy and or parking per today's discussion, if there were additional considerations. Under our districts for consideration, further review to eliminate non-residential districts or allow uses. This would include the industrial and other areas as we discussed today, and to include proposed language for a purpose for the ordinance. Does that capture your home occupancy on the types? Because it would bring forth the metrics for those.
And on the non-owner occupied, we separated to a different type, depending on single family or multi-family.
So if we had occupancy requirement, that I think then by default would then create what the non-owner occupied would be. So I have 3 items related to owner occupancy. So the first would be typical provisions for other municipalities. And again, that would then create a homeowner occupied, a non-owner occupied. Then metrics that would establish occupancy. And then how an owner occupancy would be considered under state law.
You mentioned our next meeting, the 18th of August. Tuesday would be the 16th, right?
I stand corrected. Our next meeting will be August the 16th. Thank you, Mr. Daviston. I appreciate that. Yeah. Okay. Any additions? Other discussion? If not, is there a motion?
So moved.
We have a motion from Mr. McGregor. Do we have a second?
Second.
Second by Mr. Hall. Any further discussion? Seeing none, all in favor? Aye. Any opposed, say nay. All right, motion carried. Thank you, staff, for the excellent discussion today and all the members. I know there's more to be done on this. Our other matters, we have our approval of our meeting minutes from June 21st. Any corrections to the minutes? Hearing none, is there a motion to approve the minutes?
So
Second.
Motion by Mr. McGregor, second by Mr. Hall. All in favor, say aye.
Aye.
Aye. Minutes are approved. Any opposed? Motion, minutes are approved. Is there a motion to, well, before we do that, we had no public speakers because today was our discussion. Any other matters? Thank you. So is there a motion to adjourn? Thank you, Mr. Hall. Second from Mr. McGregor. It is 11:22 a.m. and the Zoning Ordinance Advisory Committee meeting is adjourned. Thank you all for being with us today. And